Well, hello again. Thank you all again for joining us. You get to see a little bit more of me today before the conference is over, but now with a new round of panelists. So I'd like to introduce them. To my immediate left is Joshua McDaniel. Josh is an assistant clinical professor at Harvard Law School and the faculty director of the school's Religious Freedom Clinic. His areas of interest include civil rights and liberties, constitutional law, and religious freedom and free exercise issues, especially as those issues concern religious minorities. Josh is also an associated scholar with the Center for Law and Religious Freedom at the Jagiellonian University in Krakow, Poland. Josh earned his BA from Brigham Young University and his JD from UCLA School of Law. He clerked for Judge Cormac J. Carney of the U.S. District Court for the Central District of California and Judge J.S. Bybee of the Ninth Circuit U.S. Court of Appeals. Next we have Stephanie Barclay. Stephanie is a professor at Georgetown Law School and the faculty co-director of the Georgetown Center for the Constitution. Her research focuses on the role that different democratic institutions play in protecting minority rights, particularly at the intersection of free speech and religious exercise. Stephanie is a faculty affiliate at the Constitutional Law Center at Stanford Law School and a Newt Barr Fellow at the Newt Barr Institute on Law, Religion, and Ethics at Pepperdine University. In addition, she currently serves as a research associate for the Center for Constitutional Law and Legal Studies at the University of British Columbia and on the steering committee for the Quill Project at Pembroke College at Oxford University. She graduated from BYU Law School and is completing her PhD in law at Oxford University. Stephanie served as a law clerk to Judge Randy Smith on the Ninth Circuit U.S. Court of Appeals and to Justice Neil Gorsuch on the Supreme Court, which is our second Ninth Circuit Court of Appeals clerkship. And next we turn to Chris Newman, who also has that on his resume. So Chris Newman is an associate professor at the Antonin Scalia School of Law. His scholarship focuses on property theory and copyright law, with an emphasis on property doctrine and the relationship between tangible and intellectual property. His areas of teaching include civil procedure, copyright, trademark, entertainment law, and free speech. He currently serves as an associate reporter for the American Law Institute's Restatement of Property Project. Chris graduated from the University of Michigan Law School and holds a BA in Classical Liberal Arts from St. John's College in Annapolis. After law school, Chris clerked for Judge Alex Kaczynski on the Ninth Circuit U.S. Court of Appeals. So Josh, for this project, has written a really interesting paper on religious minorities and secular rights, and really looking at how Jehovah's Witnesses in particular, although a small percent of the population in the U.S. have really had an outsized impact on freedom of speech in particular. For those of us who teach free speech law, we actually know many of the seminal free speech cases were brought by Jehovah's Witnesses. So I was really interested in reading more about this. So Josh, why don't you tell us about your work?
Thank you, Joanne. It's good to be with everybody here, and I'm really grateful to the Liberty Law Center, the Voices for Liberty initiative, to put this program together and for inviting me to participate. It's been a really great experience. The initiative's goal is here at the center is to consider the role free speech has played in and continues to play in advancing civil rights for historically disadvantaged communities, minority groups. And so what my paper does is it actually looks at, it studies the interplay or the relationship between two groups at kind of two levels of generality. So the broader level of generality is to look at broadly the relationship between religious minorities and securing secular rights for other historically disadvantaged groups in terms of securing their secular civil rights. So you actually see this going all the way back to before the constitutional founding. A lot of the rights that we enjoy in the Bill of Rights itself can be traced back to instances of religious persecution. So even think, the Free Press Clause, the Free Assembly Clause, even the Fourth Amendment, protection against unreasonable searches and seizures. You trace those rights back to what were the instances of government overreach that led to the constitutional framers deciding, hey, we need to protect this in the Bill of Rights. And in many instances, it was religiously motivated persecution against people who were acting in religious capacities. You then, fast forwarding about a century, you see this again in the Civil War era, where after the Civil War, as the 39th Congress was deciding whether to enshrine the 14th Amendment, and ended up not only creating an amendment that would specifically benefit the recently freed blacks throughout America and former slaves, but to also more broadly protect the rights of all Americans and to incorporate the protections of the Bill of Rights so that they would protect all Americans. But yet again, you look back and see what was leading to that decision to apply the 14th Amendment more across the board. And you see that it was, in fact, the religiously motivated speech and other exercises of freedoms by abolitionists, both black and white, frequently religiously motivated. And so yet again, you see that pattern of religious persecution, the government tightening down on that religious action, and that leading to an expansion of secular rights that benefits everyone. So the more specific level of generality that the bulk of the paper looks at, though, as Joanne mentioned, is the case of Jehovah's Witnesses as one historically disadvantaged groups, looking at the role that they played in expanding First Amendment, in particular free speech, freedom of the press, protections for everyone, and then tracing forward how those specific rights and court victories that they obtained carried forward and essentially fueled the Black Civil Rights Movement a couple of decades later in the 1950s and 1960s. As Joanne mentioned, if you take a free speech class in law school, it's pretty hard to go through the class without getting to know a little bit more about Jehovah's Witnesses, just because despite being such a small fraction of the population, they're a very prominent part of our free speech jurisprudence, which itself is kind of a fascinating thing when you think about it. This small insular community, not many people know a whole lot about the group, but they really played an instrumental role in developing these protections. So now when you look at and just kind of another word on what led me to this was a couple of years ago, I actually was invited by the Jehovah's Witness organization to do an event with them. And someone from the General Counsel's office reached out to me, had heard about me and the work that I do with the Religious Freedom Clinic at Harvard Law School, and said that they were interested in doing a webinar that they would put online, and it was to celebrate this a 20th anniversary celebration for a 2002 decision in a case called Watchtower Bible and Tract Society versus Village of Stratton. At the time, honestly, I had not heard of that case. I was not familiar with the case, but the deeper I dove into learning about that case, the more I realized not only the value and the importance of that case, which essentially confirmed the right to essentially go door to door for whatever reason without having to first go get a permit from the government. So if Girl Scouts want to go door to door, or if somebody wants to go politically campaigning door to door, you're not going to be criminally prosecuted because you didn't first go to the mayor's office to go get a permit to do that. And in also looking at that case, one of the cases that I came across, looking at kind of the historical background behind that case, was a case of a man named Roscoe Jones, who was a black man, a Jehovah's Witness, who in the 1930s and 40s was an itinerant preacher going from town to town in the Deep South, often in heavily white areas, and preaching, but also facing a lot of persecution as he tried to preach to others and spread what he thought was the God's word to those communities that were there. And faced not only kind of brutal physical opposition but also legal opposition, where he would go to these towns and he would be arrested and criminally prosecuted for preaching or as the authorities there put it, distributing literature without a license. And ultimately, he ended up being kind of at the center of a very important shift in the Supreme Court, where in 1940 he goes to the Supreme Court and loses his case, and then just 3 years later he comes back to the Supreme Court reconsiders his case, and the court reverses itself in the prior case and actually takes the dissents from the prior case and says we're going to adopt those dissents as the court's reasoning for why we're now going to rule in Roscoe Jones' favor in this case. And so Roscoe Jones, he's been called the grandfather of the civil rights movement, so that also led me to think, well, how did he have an influence on the civil rights movement? So began looking at the civil rights movement and studying it, and turns out that, again, time after time, you see black activists who were fighting for their civil rights freedoms facing very similar opposition. So not only the violence and the discrimination that we all know about, but also having black college students in Mississippi also being arrested and criminally prosecuted for distributing literature without a license. Or being arrested for a breach of the peace violation. These same types of violations that you saw the Jehovah's Witnesses were being arrested for and prosecuted for, and where they had won these important court victories. And ultimately, you see some of these cases actually, again, making their way to the Supreme Court. And as the Supreme Court looked at these cases, these criminal prosecutions against black activists, the court, of course, turned to the Jehovah's Witness precedents and relied on those precedents very heavily to vindicate the free speech and First Amendment rights of the black activists. So I think this is a very fascinating thing to look at. I feel like I've only just begun to scratch the surface with the research that I've done here. I think there's also some really interesting implications for how do we think about these types of cases today that hopefully we can get a chance to talk about. But
Thank you. Stephanie, I'll give you a chance to respond and give your thoughts on what Josh has told us about.
Well, thank you for having me. And it's great to be here and to get to comment on such an interesting paper that Josh has written, this important topic of the role religious minorities have played in allowing for all sorts of constitutional and civil rights to be recognized that benefit all of us, including religious rights, but extending far beyond that. I thought Josh's paper does a good job breaking this into different segments of history. We look at ways in which religious minorities were influential at the first founding, then at the second founding during the Reconstruction era, and then some of the more modern cases after incorporation up until today. One of the things that I wanted to flag, because this is an area that I'm working on as well, is during the second founding, so the Reconstruction era, my co-author Kurt Lash and I are doing a project and a paper we'll post on SSRN soon about ways in which some of this abolitionist work Josh is talking about, black and white abolitionists, were deeply connected and tied to the reason that we have the 14th Amendment. There are speeches by Bingham and others talking about ways in which the rights of individuals who had religious convictions against the Fugitive Slave Act, and ways in which the Fugitive Slave Act would require them to assist with capturing or recapturing enslaved people, or even not even being able to give fleeing and formerly enslaved people a crust of bread and a drink of water. That if their conscience led them to do that, they could face prosecution. And there was such a widespread backlash against that, and an understanding that it both violated the First Amendment, but also that state and local governments shouldn't be able to do that either. And we didn't have a First Amendment recourse at that time for state and local governments. That's what the 14th Amendment does, is incorporate some of those protections against state and local governments. And so I think that's another powerful example of ways in which those sorts of movements had then resulted in much broader protections for all of us. And something that I think is interesting to contrast about that is during the first founding, we didn't focus on the plight of African Americans in this country and the way in which slavery that was taking place at the first founding also prevented them from being able to exercise their religion. And that was a huge religious liberty issue that the founding fathers treated as invisible. And maybe for that reason, they didn't think it was as necessary to have First Amendment sort of safeguards against state and local governments who were the worst perpetrators of some of the policies and laws that were taking away from these sorts of liberties. And so I think that's an interesting comparison, that when we take the broader view that is willing to look at some of the obstacles faced by religious minorities or all sorts of minorities and vulnerable groups, then it's easier for us to understand broader needs for freedoms that then ultimately end up benefiting everyone in society. That's a lesson we learned between the first founding and the second founding, and a lesson that we need to keep learning again and again, and I hope that we continue to do so. There's another thing that I wanted to point out, which is sort of the opposite, which is, or an example of us not learning that lesson, and I think is in the Supreme Court's decision of Employment Division versus Smith. And that is the case where the Supreme Court in 1990 walked back and overruled a previous regime that said that if your religious exercise is burdened, then government no longer has to satisfy strict scrutiny by showing it has a compelling interest, and that it is advancing that interest by the least restrictive means. Government just has to do rational basis review, which basically means government will always win. And in that opinion, Justice Scalia's opinion recognizes that some of the groups that are going to be most disproportionately impacted by that ruling will be religious minorities, who will have less sway, less political power to just have their religion protected legislatively. And he was like, yeah, it's like part of being in a democracy and tough, was basically the view. And there's a paper I'm working on right now with another co-author where we are looking at some of the Supreme Court papers and memos leading up to the decision of Smith. And there was this discussion amongst the justices, like, yeah, there's a lot of oddball religious groups out there, and they're kind of extreme, and do we really want to like run around protecting all of them, which I think is unfortunate. So, but that ruling, it has had a disproportionately negative impact on religious minorities, but then it also affected all religious groups in negative ways. It's a case that the Supreme Court has mentioned in recent decisions that they're at least thinking about reconsidering or overruling, and that's one reason that I hope that they will. I'll go ahead and pause there.
Thank you, Stephanie. Chris, I will give you the floor and let you comment on the things that we've heard so far.
Sure. Well, I think this was a really fascinating paper. Whenever I teach First Amendment, I always tell my students that, if the Jehovah's Witnesses hadn't existed, First Amendment lawyers would have needed to invent them. I already knew that was true going into reading Josh's paper, but I didn't realize the full extent to which it was true. I mean, if you just a cursory list I was making while reading it. So we have Jehovah's Witnesses to thank for enshrining in Supreme Court precedent the rights to distribute literature, engage in door-to-door canvassing, engage in public speech that others find offensive, freedom from prior restraint based on official discretion, use of public parks and streets for meetings, freedom from participating in forced expressions of belief. And what's fascinating to me, and one of the issues that emerges from this paper, is that in all of those cases, the witnesses were acting as an expression of their religion. They were engaged in all of those cases in what they regarded as a religious practice. And my understanding is, I'm not sure that I'm correct about this, but I think in every single one of those cases, they in fact advanced free exercise claims as part of their claims. And yet, in all of these cases, the court winds up ruling for them on free speech grounds, on sort of secular free speech grounds. And so it made me wonder, well, why do we think the court did that? Now, I don't claim to know, but I have two conjectures that I think are plausible, at least. One is, to decide a free exercise claim requires a court to opine on whether a particular practice is in fact a bona fide part of a bona fide religion. which is exactly why Scalia, in the Smith case that Stephanie was referencing, I think he felt uncomfortable doing that as part of his judicial role and didn't think that was something that judges should be in the position of doing. It's part of what motivated that opinion, I think. Whereas, to decide a free speech claim, you don't have to take any position on issues like that. And then there's also another possibility is that the court might have thought, subliminally perhaps, or more consciously, that free speech rights are more likely to garner widespread support and legitimacy because of the fact that, certainly at the time that most of these decisions were made, the U.S. and I guess still is, though despite the rise of the nuns that we talked about earlier, even though America is a largely religious population. However, I think it's probably correct to say that most people in America not everybody's religious, and of the people who are religious, most of them belong to denominations or religious belief systems that are fairly well represented and therefore are not in too much danger of having their core religious practices outlawed by secular law. Whereas everyone knows what it's like to disagree on some controversial issue and to fear having their speech shut down. I'm just throwing this out as a possible reason why, if you're being strategic about this and trying to create a doctrine that will have popular support, that might be a reason that you would do it. But what's fascinating to me about this is that I think what the court actually wound up doing was creating, in effect, a secular version of what you might call the Establishment Clause. Because a case like Barnett, where Jackson talks about the state is not allowed to prescribe orthodoxy. Now, orthodoxy, in its origin, in its core meaning, is a religious concept, right? Of course, we apply it beyond religion, but it's interesting that Barnett, and he had, in that opinion, he has a laundry list of different types of belief systems, of which religion is only one among many, in which the court is not allowed to prescribe orthodoxy. And then, you get that right winds up being, of course, as we know in Barnett, the issue was school children being required to enact with their own bodies and their own voices a ritual of allegiance, to a particular ideology, right? Which is, a very personal violation. But in short order, that opinion winds up getting expanded by the one case that involves Jehovah's Witnesses, and I don't remember seeing Josh cite in the paper. I might have missed it. But there's this case, Willie v. Maynard, where now we're talking about Jehovah's Witnesses saying, I don't want to have a government-issued license plate that has the slogan, live free or die, which whatever you think about that, it's a fair few steps removed, I think, in terms of intimate, violation of one's autonomy from being forced to actually enact a ritual, let's say. And what's interesting about, again, looking at the distinction between free speech and free exercise as a ways of deciding these cases, right? Under to make a religious liberty claim, you have to espouse some specific belief and show that the state is forcing you to contradict it as a threshold to then saying, well, the state has to justify why it's doing that to me. Whereas under the secular Establishment Clause that was created in Barnett, you don't have to espouse any particular view of your own. It's enough to say, I don't agree with what the state wants me to say, which is a much broader sort of a right in a certain sense. So what's interesting about the story that Josh is telling is, on one level, it's the perfect story for this overall initiative that we're engaged in, because what it does is it tells you this great story. Oh, look, you've got this one persecuted religious group that's motivated by religious reasons. They wind up creating and enshrining these free speech rights, which then get picked up by a racial minority and wind up enabling them to advance their cause for equality and social rights. But I think we're going to have to drill down in order to really grapple with the reasons why now there is perceived to be a tension between religious liberty and free speech on the one hand and advances to minority rights on the other. The very problem that this whole initiative is here to try to address. I think to grapple with that, we have to drill down a little more into Josh's story and ask, well, what exactly are the mechanisms that get you from free speech decisions to advancement of black rights in the US, right? And so I think there's three mechanisms, right? One is simply changes in social attitudes. There was a reason why the South needed to suppress abolitionist literature, and so certainly free speech led to a climate in which racial toleration winds up winning hearts and minds over time. That's one. But of course, what the main thing that the NAACP needed all those free speech opinions for was so that they could press for legal change. And legal change, I think, comes in two categories. There's civil liberties and civil rights. And I think we need to distinguish between the two. Civil liberties are when you are removing obstacles where the government is trying to coercively prevent you from doing something that you would like to do. So that was crucial because, that means striking down Jim Crow laws that force private parties to segregate even if they don't particularly want to. Laws that prevented people from engaging in, from having interracial marriage or from selling their house to a non-white buyer, right? Those are civil liberties, and there's no tension at all between free speech and civil liberties. In fact, free speech is a civil liberty, probably the foundational one. But that wasn't, obviously that's not all of what the NAACP did or needed to do. They also were trying to enshrine civil rights. And by rights, what I mean is rights that impose duties on both the government and on fellow citizens to do things that they might not want to do, like employ you or sell goods and services to you, or things like that. And so that's where you start to see, I think, the recent cases that are using religious liberty and this free speech version of pressing religious liberty claims. Now various parties start to feel like that is in conflict with certain civil rights goals. And so what I'm kind of interested in thinking about this dynamic going forward is, I can think of two possible ways of playing this forward. One, can we imagine a dynamic in which, just as happened earlier, some of these cases they're right now very controversial, in which, say, religious minorities are using free speech claims and free association claims to obtain rights which are essentially rights to not associate, or rights to not engage in certain conduct that other people claim is needed for them to be fully included in society. Can we imagine a situation where some future minority group is invoking those same rights to advance their interests, much as African Americans are able to advance these free speech rights? Another possibility would be that maybe the reason that we need free speech in this arena is not so much that it's that free speech is always there to expand civil rights. It may be that we need free speech in order to figure out the right balance between civil liberties on the one hand and civil rights on the other, and that it's getting the right balance of those that gets you to social progress. So I'll stop there.
Thank you all. I actually want to pick up on one of the things that Chris was raising, which is, these were Jehovah's Witnesses, obviously a religious group, and a lot of their claims you think could be advocated under the religion clauses of the First Amendment as opposed to the speech clause or the press clause. And the courts ended up, though, deciding a lot of them on speech grounds. And do you think was that for our advantage? Was that a disadvantage? What did we lose and gain from that? And then does that sort of fit into when we're talking about hybrid rights cases?
Yeah, I can start with that.
Yeah.
I think what's really interesting is exploring why that was. Why was the court bundling these rights together? One of the reasons I advanced in the paper that I believe that might have been the case was that both of these, both on the free exercise side and on the secular rights side, so free speech clause, free press clause, to different degrees, these rights were still in their infancy. So although we're in the 20th century at this point, and it's been well over a century since the First Amendment was built into the Constitution, you have very little First Amendment jurisprudence in the Supreme Court during that first century. In the free exercise context, we really only have one big case that had gone to the Supreme Court in the 1970s on a polygamy ban involving the Church of Jesus Christ of Latter-day Saints. And the Supreme Court not only ruled against the religious group in that case, but essentially did so with, today what we would look back in retrospect seems to be pretty questionable reasoning, where the court essentially said, you can have your freedom to believe, but when it comes to actually carrying out your religious beliefs into action or conduct, then you're essentially out of luck. and the free notwithstanding it being called the free exercise clause, you're really not protected by the free exercise clause if you're carrying your religious belief out into action. So that was essentially the law of the land, even as late as the 1930s, 1940s, and it wasn't really until these Jehovah's Witness cases that you started to see some cracks in the dam, and the court started to rule in favor of the religious groups. But it's almost like the court viewed the free exercise clause as too thin of a stick to rest the case on, so it had to bundle it with other sticks to strengthen it. So it's bundling it together with the free speech clause, the free press clause. To Joanne's question, one disadvantage of that is that you have you're not really clearly articulating what is the doctrinal analysis or framework under any one of these particular clauses. So if you take a First Amendment class nowadays and you look back at these cases, they're historically very interesting, and they start to develop these inchoate points, but it's still a bit messy and mushy in terms of figuring out kind of what is the test that the court is applying in these cases. And it's not until later decades that you actually get a more full-formed, workable test that operationalizes the First Amendment's protections.
Thank you. Stephanie, I'd actually be curious for your thoughts on this too, given that you do both freedom of speech and freedom of religion, and we see these cases that could really go in either direction. What do you think? We see a lot of them actually go to speech, even though they're coming from religious claimants. Like, what is your take on that? Is this to their advantage?
Yeah, so what Josh was alluding to is early in the incorporation era history of the religious exercise of freedom of speech. The court, in Barnett and in Murdoch, which are decided the same year, they're clear that the Bill of Rights and the First Amendment is providing some protection, but they do speak in fuzzy ways about both religion and compelled speech. So they're not isolating them out, in part because what the court is doing is they're like embarking on a completely new endeavor where they're like, we're no longer going to just completely defer to the government like we were in Gobitis, where we said there can be no immunity for dissidents in our country. Now we're saying the very point of the Bill of Rights is to remove some things from the vicissitudes of the majority. And in Murdoch, the court talks about how both speech and religion are in a preferred position. They haven't given us a clear doctrinal test yet for either of these. That comes in 1963 in Sherbert versus Werner, and that's a case that is clearly a religious exercise case. And so you start to see speech and religious exercise start to develop in parallel paths. The same year, in 1963, NAACP versus Button is decided, which is an expressive association case that also clearly articulates strict scrutiny, but in a speech context. So now religion and speech are both receiving strict scrutiny, and then we're off to the races, and they start to get parallel and I would say similar protection. So I don't know that it's just because the court didn't think they were strong enough and needed to grab a lot of sticks. I think it's because in the 1940s it was like we are just now barely incorporating these rights against the states and shifting gears, and so we're going to say brave things, but we're not exactly sure all of the nuts and bolts of what this is going to look like. One of the interesting things that we see now, though, is especially post-Smith, in Smith, I think Barnett had long been viewed as both a religion and a speech case. But in Smith, Justice Scalia cites to Gobitis for the idea that we just can't let religious people be a law unto themselves and object to things, even though the objection in Barnett was equally expressive and religious. It was just the same reason. I just can't do that. I can't express that thing. I don't want to say it. And I disagree that you have to have like an affirmative religious statement about all the things that you believe to bring a religious exercise claim. It's enough to say, my religion tells me I cannot say this thing. So it's a very similar basis for the exact same outcome in that case. And so Woolley versus Maynard is another interesting case where you have a Jehovah Witness who, for religious reasons, is saying, I can't have a license plate that says, live free or die. I disagree with that message. He disagrees for religious reasons, and so it's just an interesting now dichotomy where under the religious exercise clause, that's probably just a generally applicable law and there's no remedy for him, but under compelled speech doctrine, there is. And so that shift, I think, happened with Smith, and I think it has created somewhat of a double standard in the law, and is the reason why now, in future cases, like in Masterpiece Cake Shop or through Creative or other sorts of cases, if people can bring an expressive claim, they will, because there's an argument that those sorts of compelled speech arguments can be stronger.
And that actually brings me to, I think it coincides nicely with where I wanted to go next, which is, this paper focuses so much on how this religious minority managed to secure rights that then other minority groups have used to promote their own civil rights, equality, and freedoms. And one thing we're seeing very recently in cases like 303 Creative or Masterpiece Cake Shop is the argument that now we have religious groups using free speech to harm minority movements or to the harm of like LGBTQ rights or things like that. And so, Chris, I know this is something we've talked a little bit about. Why don't we get your thoughts on that initially and then maybe thoughts from the other panelists?
Well, sure. I mean, that was where I was, closing, my own remarks. And what's interesting to me about this area is that notice that when you have a religious motivation for not wanting to comply with some state regulation of conduct, if you try to bring that as a free exercise claim, I'll take Stephanie's correction that you may not have to describe in detail exactly all of your talk, but the point is you have to claim that your objection is based on a religion as opposed to I just don't agree with it. Yeah, on a religious belief, as opposed to just ideologically, politically, I think it's bad policy, I don't like it, it's too inconvenient, right? Whatever other reason you might have for objecting to a law that you might feel equally strongly, let's say, you can't use that. You have to have a religiously grounded belief in order to escape from a law that is regulating your conduct, if the conduct is regarded as general non-expressive conduct. To bring the free speech claim, now, what we're going to be, from 303 Creative on, now we're going to have a lot of cases trying to figure out under what circumstances is conduct that the state is trying to compel you to engage in, is it speech conduct or not? Is it expressive conduct or not? And so we're going to be trying to see how far the contours of that doctrine go, in which case it doesn't matter whether you have a religious belief or not, even though you may be motivated by religion. All you have to do in that case is say, you're trying to force me to say something and I don't want to say it, which is really, now in terms of, so what I'm interested in thinking about is, obviously, right now, the reason why religious liberty and free speech are both in somewhat of a bad odor, let's say, among forces that are politically primarily concerned with advancing the rights of certain groups, primarily, obviously, in this arena, we're talking about LGBT groups, though I'm not sure that will always be the case, that there's that perceived tension, right? And so I'm curious to see whether, I think part of it has to do with what I would regard as perhaps an unwise overexpansion of what we think the scope of necessary civil rights are, right? Because it's one thing to say, I want civil rights to be permitted to participate fully in society. I want to be obviously treated with dignity. I want to be protected from harassment and oppression and stuff. But then when you get to the point where you're saying, my civil rights require that everyone be willing to associate with me and almost, and if they're willing to publicly associate with other people or to condone their conduct, they have to condone mine and associate with me. You're getting to the point where, so, there's a tension there. It's sort of coming from both sides. I don't think it's, so that's why I'm really curious to see whether going forward, to me, the really smart strategic litigation, I don't know what this would look like, would be to find cases where there are minority groups whose rights progressives want to protect and expand, who themselves have a need to be able to have the autonomy to define themselves by not necessarily allowing other people to associate with them in every way, or not necessarily, the question is, what things are we willing to agree to disagree on, and what things do we really think we have to force everybody to agree with in order to have a civil society? That's obviously the hard fight, but I don't have a clear answer to it. I wish I did.
It's a hard one. Josh, what are your thoughts on this? Have we, are equal protection and free speech and equal protection of religion now sort of coming into conflict compared to sort of what religion was doing to advance free speech in the past?
Yeah, this is a really important question. It's something that's coming to the fore a lot more nowadays. I think one of the things that I try to do through the work at the Harvard Religious Freedom Clinic is to demonstrate through our cases that frequently there isn't a conflict there, and that in really the mind run of religious freedom, free exercise cases that you have out there, that you don't have these types of conflicts. But when you do, they're obviously difficult cases, and neither the free exercise clause nor the free speech clause is absolute, and courts are going to have to figure out how to sort out these issues. That said, I think there are some interesting analogs if you look to these prior cases in the 1940s and then beyond. If you take this case, Cantwell versus Connecticut, for example, from 1940, which was the case where the Supreme Court incorporated the free exercise clause against the states. The fact pattern there was that you had Jehovah's Witnesses on the street using the really advanced technology of carting out a phonograph onto the street and rolling it around in places, and then playing the phonograph for people that would listen. And it was a pretty overtly, blatantly anti-religious message targeting the Catholic Church. And the name of the phonograph recording was Enemies. And the part of the reason why doing this actually led to them being arrested was that it was really angering some of the people on the street that had heard this message, to the point where a couple of witnesses said that they wanted to go and actually physically assault the Jehovah's Witnesses because they were insulting their religion. And essentially what the Supreme Court said in that case was that in order to have kind of a free debate both in the religious context and in a political context or in other contexts of public concern, that we need to have what the court called breathing space. We need to have kind of some allowance in the law to have difference of opinion, even when, as the court said, somebody's espousing the view that's kind of the rankest error in terms of how somebody else would view it. And then you actually had that very quotation and that very point that the court was making in Cantwell then becoming relevant again in the black activist cases, where black activists were speaking to large crowds and saying things that significantly angered some of the white onlookers that were there, and the police were concerned that this is going to lead to some kind of a race riot here, and that there's going to be physical action between the people here, and so they arrest the Jehovah's Witnesses. And again, the court points to the court's quotation in Cantwell and says, no, again, we need this breathing space, and there is going to be a limit to the First Amendment protection, and that limit certainly will be reached when you actually get to the point of calling for people to engage in harm against other people. But because in both cases, the Jehovah's Witness and the black activists had not reached that point, the court recognized the protections in those cases. So it's going to be difficult to think about how does that apply in cases currently in these very difficult cases. But I think what we do see is that at the time these were very controversial cases, but as society kind of as time passes and what was once controversial perhaps is no longer so controversial, then I think we start to see the value in terms of this expansion of secular freedoms that can be used.
Stephanie, what are your thoughts on this, potential tension between these values?
Yeah, so I think that certainly sometimes there are real conflicts between individual interests and aspects of importantly held parts of individuals' identity and their deepest held convictions and the way that they want to live out their lives that are tough. And so there are tough cases, but and Professor Laycock has written about the fact that LGBTQ individuals and religious people, in some ways, it's artificial to put them in silos because you have sometimes religious LGBTQ individuals, so we can oversimplify those silos. But folks with those characteristics have a lot to learn from each other because they both have in common that they're trying to live their life consistently with a deeply held aspect of their identity. When he said that, I thought that was interesting. He's an individual he's a professor who is neither religious, he's an atheist, and he's also not LGBTQ, but he has advocated for rights of both of these groups, and he has advocated for compromises where states can have legislation that protects both. Or I think of people like Dr. Reverend Marian Edmonds Allen, who is a gay woman who advocates for religious liberty, but also works with states like Utah to pass legislation to protect LGBTQ individuals. There was a case in Kentucky where there was a printer that was requested to print some T-shirts for a gay pride parade. And this was a religious printer, and they said, I can't print those sorts of shirts. I don't print lots of things. I don't print things for Halloween because of my religious beliefs, and I can't do that. And it actually wasn't an LGBTQ individual asking for the shirts. Interestingly, it was a white heterosexual male. He was an ally of the group, but he was the one making the request. And there were 2 lesbian women, business owners, who came out and issued a statement supporting the printer. And they said, look, there's a lot of messages we wouldn't want to be forced to print. And we remember what it was like to have government being much more invasive in terms of what we could express and the type of persecution we faced. And we think that he should be able to express messages he does or doesn't agree with, even if we see the world differently than he does. And I thought that was admirable. So that's one thing that I think is always valuable in America, is when we scramble this narrative that it's like this group against this group and they're in an intractable conflict, and try and find ways where we can ask, how can we protect each other's rights? How can we alleviate this tension? How can we find common ground? And I think as more of us are willing to ask more of these questions, I think some of those conflicts are unnecessary.
So one thing that occurred to me when reading your paper, Josh, or your draft paper, is, Jehovah's Witnesses is such a tiny group, and so I'm just curious, why were they able to have such an impact? Why them? And I think looking forward, is there something that other groups can can use as a model or example, or how can they learn from what the Jehovah's Witnesses have been able to accomplish?
Sure. So I think there's a lot of reasons why, the question of why Jehovah's Witnesses, why at this historical time period were they the ones that kind of took up the mantle of doing this. It's very nuanced and complicated. I think some of it is just because of the cultural moment in which they found themselves and the conflict between that cultural milieu and their theological beliefs. They have a view of the state where they're really kind of considering themselves as a community apart. They don't participate in the political process. They don't register to vote. They don't register with party affiliation. And then when you had in World War II era, as the situation in Europe was looking very bad before the U.S. had entered the war, and then as the U.S. did enter the war, and you had this prospect of everyone sending their sons to war, and the Jehovah's Witnesses are not only saying, no, we're going to abstain from the war because we don't want to go fight the war, but we're also not going to pledge allegiance to the flag. At that time, that really just it angered a lot of people. It upset a lot of people. So too with their kind of anti other religion sentiment of going around and playing. If you're in kind of a majority Catholic area and going around with a phonograph that's playing anti-Catholic messages, that's not going to make people very happy. And so there was all of that, and I think added to that, because Jehovah's Witnesses don't believe in either voting in elections or even going and lobbying legislators to try and get change that way, even if they could, which is also doubtful because they're a minority viewpoint. For them, the courts really are their only recourse within the government that they felt comfortable pursuing. And so for them, it was really either the courts give them the the right, or there's really no other way to accomplish it. So in some ways they were kind of cornered into this situation where they really had little other choice from their perspective but to pursue these cases very vigorously, pursue them all the way to the Supreme Court, and to do it over and over again. And in terms of what others can learn from it, I think the final thing I would say about the Jehovah's Witnesses was they were also very smart about it, and very prepared and very coordinated, even getting to the point where they were sending out pamphlets and literature and training kind of all of their the members of their organization on, okay, if you get arrested, this is what you do, know your rights, this is how you act, this is who to call, and kind of organizing, who are the lawyers that are going to help with this, and then from the top looking at how are we going to litigate these cases, things like, we're not just going to bring free exercise claims, but we're going to bring free speech claims and free press claims to increase our chances of winning. And so in some ways it was also just brilliant legal strategy that helped this campaign to succeed.
Thank you. Well, I do want to give time for the audience to ask questions, and I see there's a lady in the middle there, if someone could bring her a microphone.
As a non-lawyer, I really appreciate understanding the difference between free expression and free speech. It occurs to me, what do you think about the possibility of Jews going before the court and arguing that anti-abortion legislation violates the free expression of their religion? In other words, anti-abortion laws have an either explicit or implicit religious content, which is Christian. Is anybody doing that?
Yes. There's a case in Indiana right now where a group of Jewish individuals, an association that represents them, has made a claim that Indiana's pro-life law that defines abortion with limited exceptions as termination of the embryo after conception counts as abortion. So it's a very protective and restrictive about abortion sort of law. So that association sued. They brought a religious exercise claim. I don't think it really matters whether they bring a religious exercise or speech claim ultimately, because Indiana has a RFRA. And so they both, either way, either path gets you to strict scrutiny. And that's where I think that claim has a hard time, because the government is arguing, and they did win at the appellate level. It's gone up to the Supreme Court. And so the challenge I think they will face at the Supreme Court is that the government is saying, after Dobbs, state governments have the right to define life as beginning at conception. And it's a long agreed principle that protecting human life is a compelling government interest. And in this context, when we restrict these abortions, every time we do that, we're protecting a human life. And so there's no less restrictive means of doing it. So whether it's speech or free exercise, I think that's the challenge.
The definition of life is itself a religious definition.
The Supreme Court said that states have the right to define that politically. And so like we define life for scientific reasons. That's different than saying when somebody has a soul, which is a religious question. There are a lot of moral or scientific reasons why we draw arbitrary lines all the time about when someone is alive and when they're not.
So when you say it requires strict scrutiny, is that because Jews are not in the category of strict scrutiny?
No, strict scrutiny protects the Jews. So strict scrutiny means that the Jews get to hold the government to the highest standard we have under constitutional law, but it is sometimes the case that government can satisfy that standard anyway.
Yeah, strict scrutiny means we're going to subject the government's law to strict scrutiny to see whether it has a sufficiently compelling justification to overcome the right asserted by the private party.
And I'm going to open it up for other questions before we, to make sure that everyone gets a chance.
I'm kind of curious about this issue that has been sort of foreshadowed in some of the discussion about a contention of rights between freedom of association and freedom of speech. And I'm thinking here of Mary Ann Glendon's work, Rights Talk, about sort of drawing inspiration from like a European model where there's sort of cultural it's sussed out the barriers and the boundaries, and is sussed out in a cultural manner, so to speak. These non-governmental and governmental organizations sort of pronounce forth this, that, or the other, and sort of it's hashed out that way. What determines whether or not the Supreme Court deigns to weigh in on this? Is it required to do so in your estimation, or could it just sort of move on to other issues? Is it inevitable that the Supreme Court is going to have to take a case like what you're suggesting here, Chris?
What case specific? I didn't quite follow. What case specifically are you positing?
Some of the discussion is about this sort of you're seeing two trains sort of heading towards one another here with the issues of the Masterpiece Bake Shop here, right?
Mm-hmm.
With the freedom of speech versus freedom of association here, right?
Well, I mean, they already are deciding cases like that, and they're going to have to continue to do so because 303 Creative was sort of made artificially easy by a lot of stipulations that I think in other cases are probably going to have to be litigated. And what I mean is you're going to have questions about things like, is the conduct that I'm being required by a public accommodations law to engage in, like printing a T-shirt or making a cake that I don't want to make because of my religious reasons, right? There's going to be questions about, well, is that particular conduct actually, is requiring you to engage in that conduct actually tantamount to forcing you to engage in an expressive act? That's where and there's going to be, fact-based, I think, arguments that are still going to come up. I mean, I think the Supreme Court's already said in 303 Creative what the basic rules are, but again, there's going to be hard line drawing, I think, in some of the actual facts. Do you agree? Or?
Well, I don't see any other questions from the audience, but I guess I will ask the panelists. Do we see, is there anything sort of pending that might come before the Supreme Court that might affect the things that we've, like specifically pending, like specific cases that might affect some of these rights we've been talking about today?
Well, I can't speak so much to I'd have to give some thought to the pending cases or the upcoming cases, but I think the most recent question, I think one of the interesting things that you do see recently, so with cases like the shift from the Masterpiece Cake Shop case to 303 Creative, you see this interesting shift where in the first case, the court decides the case on the free exercise of religion grounds, and on the second case, although both free exercise of religion and freedom of speech were raised as claims in the trial court, the court only granted the case on the free speech issue. So it said, we're only going to decide the free speech issue in this case. An interesting parallel to some of the other cases that we're looking at where there's this option that the court has of which ground does it rule on, and the court is very overtly choosing the broader non-religious ground in that case. I think another interesting case is, for those of you who are familiar with the Coach Kennedy case, the Kennedy versus Bremerton School District case with the coach who wanted to take the knee at the 50-yard line. One of the, I think, frequently overlooked interesting things about that case is the fact that it was not just a free exercise of religion case, it was also a freedom of speech case. And in that case, the court, instead of choosing one or the other, it actually chose both. And it said, we're going to decide on both grounds. And so it did the full analysis under the free speech clause and the full analysis under the free exercise clause, and essentially got to the same result under both clauses. But I think that raises interesting questions about in what future secular kinds of cases will that case be a precedent in the future, given that it's not limited to religious context. It's overtly expanded beyond that.
And an interesting flip side of that is sometimes the court has had both options, speech and religion, and has just chosen religion. So in Masterpiece, they could have decided that case on speech grounds or religious grounds, and that time they chose religion. In Fulton versus City of Philadelphia, where the court ruled unanimously in favor of a Catholic foster agency, they also brought a speech claim in that case, and the court said nothing about speech. So it is an interesting puzzle, like why sometimes are they reaching for speech, why sometimes are they reaching for religion. One other thing I wanted to mention really quick is, in terms of cases, there's none pending that the court has granted that I think answer this question, but I will flag one case where I'm counsel on, where we represent Apache stronghold, so a group of Native American practitioners in Arizona, where the government would like to turn their sacred site that has been sacred to them from time immemorial into a copper mine, and make it so that it's impossible for them to practice their religion anymore. And this is a context where I think the legal standard that exists, what constitutes a substantial burden for religion, protects just about every other religious practice except for this particular type of one. But what has been meaningful in that case, so I represent them alongside the Beckett Fund, and there's been this huge coalition of other religious groups or non-religious groups, the ACLU, to Catholic groups. I think Josh's clinic filed something in that case. All coming together in the amicus support and saying, look, we don't share these same beliefs, but it's not okay for our laws to be gerrymandered and have a carve-out that just doesn't protect Native American practitioners with their particular type of religious exercise, even while the law is protecting everybody else. So I'm hopeful that that will be a case that the court takes.
Can I just say real quick on that? 1 minute.
30 seconds.
Okay. In the reason that they broke for free exercise in the Masterpiece case was because that was actually the easier answer in that context, because they had the evidence of animus, which means it wasn't a neutral law of general application, right? They wound up deciding, I think, they wound up deciding it that way because they say, oh, here we can tell that the law was actually motivated by animus against religion, which is the one time that becomes an easy case, easier than having to do even the free speech side of it. And then in the Coach Kennedy case, it seems to me that they sort of had to reach both, because the schools, as I understand it, the school's justification for why they didn't want him to pray was because they thought it would violate the Establishment Clause. So they had to sort of decide whether that was even a valid, if that was their only reason for not wanting him to do it, they sort of had to reach both sides of it. Anyway, that.
Well, thank
Is
you.
that not right?
Yeah, with that, I'm going to wrap up the panel just because we are taking a short break before our final session, which is our plenary, which will feature Eric Smith and John Wood Jr. and Debbie Gate talking about whether there's room for freedom of speech within civil rights movements. But I'd like to really thank our panelists and our author for this really interesting discussion. Thank you.